So just when does commerce become interstate commerce? More importantly, when can the federal government meddle in a person's commerce? The Federal Arbitration Act, FAA, requires courts to enforce many private arbitration agreements, but it also provides that nothing in the law shall be used to compel arbitration in disputes involving contracts of employees of any class of workers engaged in interstate commerce. That's Title IX U.S.C. Section 1. This case poses the question of whether someone can qualify as a worker under Section 1 exemption if he never crosses state lines and never interacts with vehicles that do. Many employment contracts include an arbitration clause, which requires most issues between employers and employee be settled by binding arbitration rather than a lawsuit. Congress told the courts of the Federal Arbitration Act that it must enforce those arbitration clauses. Article 9, Section 1 defines for the purposes of this law what interstate commerce is. Now, Angela Brock held a franchise that transports goods produced by Flowers Foods, Inc. in the Denver area. In 2022, Brock sued Flowers in federal district court, alleging that the company had underpaid him and other distributors in violation of various federal and state laws. Flowers moved to compel arbitration, arguing that the FAA generally requires courts to stay or dismiss cases when the parties have agreed to resolve their disputes by arbitration, and that Brock had signed a distribution agreement promising to arbitrate any disagreement. The district court denied Flowers' motion, and the 10th Circuit affirmed. Resting its decision in Title IX, Section 1, the 10th Circuit reasoned that Brock belonged to a class of workers engaged in interstate commerce, and thus the court lacked authority to compel arbitration. Now, Mr. Brock only transported goods within the state of Colorado, so how does this qualify as interstate commerce? The statutory text does not support a rule requiring workers to cross state lines or interact with vehicles that do. When the FAA was enacted, to engage meant to take part in something or to be employed or involved in that thing. And interstate commerce meant traffic, intercourse, or the transportation of persons or property between or among the several states, or from between points in one state and points in another state. Nothing in those terms requires an individual to cross state lines or interact with a vehicle that does. Okay, according to SCOTUS, Mr. Brock did take part in interstate commerce, even though his portion was solely within a state. And in this case, Mr. Brock was part of a transportation chain that included interstate transportation, i.e., interstate commerce.